Sam Seder on the Majority Report. Emma is out today. I forgot to mention that earlier on, but Emma is out today. She will be back tomorrow, getting over the flu. Fortunately, joining us now, not ill with the flu, Mark Joseph Stern, senior writer at Slate. Mark, welcome back to the program.
Thank you so much. Happy to be here. You know, it turns out that the last time I came on, I was in the early stages of COVID. I discovered a day later. Oh, wow. Right now, I'm feeling 10 out of 10, so you don't need to worry about brain fog.
All right. Fantastic. I didn't pick up on it, but I'm glad to hear that. All right. I want to go through, and we don't really know the full docket yet, right? For 24, 25. Well, broad stroke, do you have a sense that, like, at least at this stage, the court is sort of like trying to tap the brakes a little bit? I mean, it is, in terms of controversy. I mean, John Roberts, there was a sort of a devastating piece. I think we talked about it last time we were on, maybe, on John Roberts in the immunity case. And supposedly he was really hurt by everyone's reaction to it, which I found charming. But what's your sense of, like, you know, is it just by chance as to what we're seeing so far on the docket?
Yeah, I think it's less that the court is tapping the brakes and more that the court is trying to hold all the major cases over until after the election. And, you know, something that we learned during the whole Dobbs controversy and after is that the court actually voted behind the scenes to take up Dobbs months before it revealed to the public that it had voted to take up Dobbs. So, you know, Dobbs is the case that overruled Roe versus Wade. Traditionally, and according to the rules, when the court decides to take up a case, they're supposed to announce it in the next orders list. But with Dobbs, they said, well, this is going to be really controversial. We want to hold it over till next term. So we'll just keep it a secret that we have decided to take it up and drop that news later on. I think that might be happening with some really big cases this term. You know, there are major petitions on the docket involving, say, the death penalty and assault weapons and the Second Amendment that I feel like the justices are going to take, and they're just waiting until November 6th to announce it. I think they do not want to be in the spotlight for this election, which they should be, no matter how hard they try not to be. But it seems likely that in December and January, we're going to see the term rounded out with some gigantic and hugely controversial cases. So it's just it's a when, not an if.
Am I? I mean, I have a feeling I know how you're going to respond to this, but I feel like it needs to be said. It seems to me that it is incredibly effed up that the court is trying to diminish its import in the context of an election, because I don't know, particularly when we have, you know, it's very likely we're going to have a split government, regardless who wins the presidency. The appointing people to the Supreme Court, you know, Donald Trump had maybe the most Supreme Court justices appointed in 4 years that we have seen, certainly in my lifetime, I believe.
In modern times, for sure.
Yeah, in a first term. And the idea that they want to sort of just like hide out and pretend they don't exist in the context of an election seems to me to be a little bit contrary to, I don't know, just basic civics.
Yeah, I think that's a huge part of it. I also think, and this gets sort of technical, but is overlooked too often, Congress has relinquished control over the Supreme Court's docket almost entirely. And that is a contemporary phenomenon. Right up until the 1980s, Congress told the Supreme Court which cases it had to take and identified certain classes of decisions that the Supreme Court had to hear and decide on appeal, including a lot of major cases. And in the 1980s, Chief Justice Rehnquist basically convinced Congress that the court was working too hard and that it needed to have total control over its own decision making about which decisions it would make. And Congress has sort of just taken its hands off the court and given it absolute discretion to choose when and how to take cases and exactly which cases it will take and which cases it won't take. So, like, you know, a sensible Congress might have looked at that decision out of the Fifth Circuit that denies women the right to get emergency abortions and said that's a major case, the kind of that that the Supreme Court should have to take. But instead, it's totally discretionary. So the Supreme Court just denied it without saying anything else. And women will continue to be forced to the brink of death in Texas and other red states because they can't get emergency abortions. This Supreme Court is really good at manipulating its docket to create an image of moderation and to just play the schedule of elections in a way that always redounds to its benefit.
I'd love to see somebody introduce the return to the Reagan era time where the Supreme Court took its instructions from Congress. All right, but with that said, assuming that's not happening, the major cases that the Supreme Court has admitted to has publicly announced that they would be dealing with this year.
Yeah, so I mean, we've heard a few, and the news is mixed, I would say. So the Supreme Court took up a case called Garland versus VanDerStok, which is about ghost guns, which were these weapons that you would buy in the mail. They would be partially disassembled. You'd watch a YouTube video, they'd say, remove this plastic strip, drill a hole right here, and then you've got a perfectly firing gun. And people who bought ghost guns didn't go through background checks. The guns were not serialized. There was no record keeping. And the creators of these guns, the manufacturers, were basically open that they were selling these guns to criminals, that the whole purpose was to sell guns to be used in crimes that were untraceable by the police, and found a large class of criminal clients who made the industry millions of dollars right up until 2022, when the Biden administration said, hold on, this is not legal under the Federal Gun Control Act. These purchases have to go through a background check and the guns have to have serial numbers. Once that rule took effect, the entire industry was basically destroyed because they could no longer sell directly to the criminals who were their clientele. And VanDerStok was a challenge to that rule that had sort of decimated the industry. The Fifth Circuit, of course, which is crazy, had purported to strike down the rule. I think the Supreme Court's going to uphold the rule. I think we're good on ghost guns, if nothing else this term, because I think that the sellers of these guns, sort of merchants of death, they flew too close to the sun. They made it too obvious that their entire business was built around allowing criminals and young people with mushy, underdeveloped brains to buy guns and shoot people. And at least John Roberts and Amy Coney Barrett are not going to go along with this scheme to revive the ghost gun industry.
Two things what strikes me. The first one is there, do manufacturers of ghost guns and sellers of ghost guns, do they have the same immunity that gun manufacturers have? I mean, in other words, like, it seems to me that, and this is on my brain because I just came back from the tort conference a week or two ago that I attend on a regular basis. Seems to me there's got to be a couple of good plaintiffs out there to essentially like sue these people, off the plane of existence, essentially.
I love that you were at a tort conference, first of all. That really warms my heart. And your question is exactly
a year.
Right.
Twice a year,
amazing.
Buddy.
Oh my God.
For
I gotta
a decade.
Somebody sign me up for this, please. Your question is just right. What happened before the Biden administration had stepped in was that individual plaintiffs were suing the sellers and manufacturers of these ghost guns, which are often one and the same. Some warehouse out in Nevada or Texas was making and selling these guns, and winning those suits because these are not licensed firearm dealers. These are not licensed firearm manufacturers. They are not protected by PLACA, the federal shield law that generally prohibits any kind of civil liability for sellers and makers of guns. So there was a lot of progress before this rule took effect where, the victims of some horrible crime committed with ghost guns would file suit and win. But it was like a whack-a-mole situation where the companies would just dissolve and keep popping up under a new name. It was like a fly-by-night situation. We needed this one federal rule to do what sadly tort law couldn't quite accomplish and shut down all of these guys. And it's worth noting, not by outlawing ghost guns. Like, you can build your own gun legally if you want. All the rule did was say you have to follow the same requirements that real gun dealers follow. And it destroyed the industry because their whole business model was not following those rules.
You've mentioned the Fifth Circuit twice so far. And I imagine that a lot of those gun manufacturers in Texas use the Texas two-step as a way of escaping on some level the any type of liability in those cases. Again, a function that's statutory in Texas, but just remind people about our circuit system and why the Fifth Circuit is something you keep hearing over and over and over again, and why it is in Texas, if you are needing an emergency abortion under federal law, any hospital that receives Medicare or Medicaid, I should say, money is required to provide emergency services when necessary. But in Texas, their abortion ban overrules this, but only in Texas, Louisiana, and what's the third state there? In Mississippi. Will you just explain this dynamic to people? Because it's fundamental so that in terms of what's going on in our court system right now.
So the intermediate courts of appeals, in between the trial courts and the Supreme Court, are where most cases are decided. Like the overwhelming majority of cases end at the intermediate courts of appeals. They're called the federal circuit courts, and each of them covers a different geographic area. So the Fifth Circuit covers Texas, Louisiana, Mississippi. The Ninth Circuit covers like the entire West Coast and Hawaii. The First Circuit is the Northeast. And essentially what happened with the Fifth Circuit is that under Obama, Republicans in the Senate held open several seats and refused to let Obama fill them. And then Trump came in and filled those seats with like militant far-right extremists, and several other judges took senior status and allowed Trump to replace them as well. So you have this like militant majority on the Fifth Circuit that is, I mean, most of these judges are frankly just auditioning for the Supreme Court if Trump wins again. Like their whole deal is that they're trying to jump up and down and say, look at me, daddy, I'm the one you want. I'll be loyal. I'll be crazy. And so they're issuing these decisions like the one that said that women can't get emergency abortions, even though they're protected under federal law, like the one saying that ghost guns are, protected class of commerce, and that the Biden administration has no power to restrict their sale, or many, many other crazy decisions. Trying to roll back or ban medication abortion was a big one last term. Trying to abolish the entire Consumer Financial Protection Bureau. It was also the Fifth Circuit that held that domestic abusers have a Second Amendment right to own guns. So what I think Republicans have shown is that it's actually really easy to capture a circuit and to then use that circuit to sort of drive the law rightward. Right now, about a quarter of the Supreme Court's entire docket is devoted to Fifth Circuit cases because they are so aggressive and so wild, pushing, maybe like it's an Overton window thing, right? But they're pushing these agendas and forcing the Supreme Court to at least consider and often overrule some of their big swings. So that's why I keep talking about the Fifth Circuit. It's not because I'm obsessed with it. It's because it is obsessed with destroying the law.
Has there been a case in a different circuit over the emergency abortions? And do we need one to essentially create a conflict in the law so the Supreme Court actually has to address, instead of just pretending the Fifth Circuit didn't just sort of, at least on its face, completely upend federal law?
Yes, there was. There was one in the Ninth Circuit, which is one of the more liberal circuits. And the Ninth Circuit had protected women's ability to get emergency abortions in Idaho, which is somewhat oddly squeezed into the Ninth Circuit. And you might remember last term, the Supreme Court took up that case to consider what the Ninth Circuit had did, and then ended up dismissing it and said that it intervened prematurely. So there is an active conflict of the law right now. If you live like in within the Ninth Circuit, or even in Idaho right now, you have a right to emergency abortions. If you live in Texas, Louisiana, Mississippi, you don't. That's the kind of thing that the Supreme Court is supposed to iron out. Like their number one job, I would say, is to create uniformity in federal law. But they just denied the abortion case out of the Fifth Circuit.
How rare is that? I mean, that just seems nuts. I mean, this isn't like, there's some question about, paragraph 5 in the bankruptcy code and it's unresolved and it's something that we're going to get to or something like that. This seems to be, literally a matter of life and death. I mean, almost like definitionally, right?
Yes, I would say it is getting less rare as the Supreme Court is getting even more cynical about crafting its docket in a way that sort of gives it maximum political cover. There are some big circuit splits that the Supreme Court just does not want to address. Some of them involving immigration, some of them increasingly involving LGBTQ rights, although we'll talk about one of those splits in one of those cases soon. And I just think that the justices are like, I wouldn't call it quiet quitting, but again, they don't want to take too many cases every term. They used to take 150, now they take like 60. And they don't want to draw too much public ire, except when they have a really deep passion, like they do for protecting Donald Trump from criminal prosecution. So we just let these circuit splits linger, and it means depending on where you are in the country, your federal rights differ wildly.
That to me just is, and in this instance, it's not just your rights. I mean, like you're in
life.
Texas, you're going to die.
Yeah.
In that situation. Let's just briefly touch on the Comstock Act, which I know you anticipate will reach the Supreme Court probably sooner rather than later. What is the Comstock Act? Why do you think it's going to reach the Supreme Court? And then we can move on to different cases.
So the Comstock Act is a law enacted in 1873 in a fit of sort of moral panic about women's rights. That was chiefly designed to prohibit the mailing or the spread of pro-feminist literature, as well as birth control, which was still a relatively novel thing back then, and includes a provision that in somewhat ambiguous terms, suggests that it is a federal crime to mail or otherwise transport any instrument or drug or thing that can cause abortion. Now, that is a really big problem for reproductive rights today because, as we're talking, something like 2/3 of women in America terminate their pregnancies with medication abortion, which is very safe and effective. It's been approved by the FDA for 24 years. And, more broadly, like, abortion clinics, where they are legal, rely on the transportation of tools and other things to be able to perform procedural abortions in the doctor's office. So if you read the Comstock Act like very, very literally, it means that there is already a nationwide abortion ban on the books, that medication abortion is illegal, that abortion tools are illegal, that basically everywhere in the country that abortion is happening, that's a federal crime. One of Trump's top lawyers, Jonathan Mitchell, who has argued on his behalf at the Supreme Court, he has said that if Trump wins, he will use the Comstock Act to ban abortion. He said, we don't need Congress to act because we already have the Comstock Act. And that is also in Project 2025. So I think that, if Trump wins, that is going to happen to some degree. There's going to be some executive effort to restrict or ban abortion, even in blue states. If Trump loses, we already have red states in federal court trying to use the Comstock Act to outlaw the transportation and mailing of abortion drugs. So one way or another, this issue is being teed up for SCOTUS. SCOTUS does not want to decide it right now, but after the election, anything goes.
And we should say, even if the Democrats get the House, get the presidency, and get the Senate, they would need 60 votes in the Senate as it stands now to reverse the Comstock Act, because this has nothing that apparently implicates or obviously implicates the U.S. budget. And you can't do it through reconciliation. You really just have to basically get rid of the filibuster, at the very least, for this vote. And I don't know. Hopefully that would be something they would do if they were in that position. But get ready for the abortion. It's really a stealth federal abortion ban is really what we're talking about. That is what
Trump's top lawyer has called it and intends to use it as, yes.
Let's move on to U.S. versus Skrmetti. Is that how Skrmetti? Yep. This is a case that's definitely that the court has already announced that it's taking.
Yeah, but won't hear arguments until after the election. So,
very convenient.
Delayed those arguments for an unusually long time to ensure that they would happen in December instead of November, for what it's worth. These cases, this case is a challenge to red state laws that prohibit transgender youth from accessing hormone therapy, including puberty blockers. It's not about surgery. It's only about puberty blockers and cross-sex hormones. And it involves Tennessee, which is one of almost half the states in the country that have imposed these bans on healthcare for transgender youth, and said, and I think this is important and often gets lost. A cisgender child who needs hormone therapy or puberty blockers, of which there are many, they can still access that care. There's no problem there. But if a child comes in and says, I am transgender, they are legally prohibited from accessing any kind of hormone therapy or puberty blockers. So like a 9-year-old boy who's undergoing puberty too early can get a puberty blocker for that. But if a 9-year-old comes in and says, I was assigned male at birth, but I think that I'm trans and I need time to consider it, they're not allowed to get a puberty blocker. Directly targeting trans people and also classifying people on the basis of sex in a way that the Supreme Court has previously said is unconstitutional, and also that, violates equal protection to sort of engage in this overt discrimination on the basis of, what someone was deemed at birth, male or female. I'm not super optimistic about this case. I do think there's some hope. I think that logically it follows on the heels of the VanDerStok decision in 2020, where the Supreme Court said that you can't discriminate against trans people without discriminating on the basis of sex. But this is still the Dobbs court. And I fear that they're just going to say, there weren't trans children in 1789, so trans children today have no federal rights.
Well, there also wasn't hormone blockers in 1789. So how does anybody have, is there a precedent for statutory intervention in a doctor prescribing medication for some symptoms, but not another? I mean, this is what's insane about this. Like, there are times where the FDA says, like, all right, you can't use this for off-label, right? Like, let's say just like the Ozempic. Like, the idea that there would be a statute that would be written in the state of whatever, whatever state it is. You can use Ozempic for one set of symptoms or indications, but not for another, not based on any type of medical data whatsoever. Just like, we just think that it's a little bit lazy of you to use it if you're overweight. And it doesn't, morally, it just feels like you're not working hard enough to lose weight. And so therefore we've decided no.
It is extraordinarily unusual to see states step in and, in many cases, criminalize with felony penalties the provision of a certain kind of care or medication under these narrow circumstances. And it is even more unusual, it's just downright aberrant, for a state to do so on the basis of sex. I just can't stress enough that these laws decide who can access certain kinds of care solely based on the sex that they were assigned at birth, not based on, in my view, any kind of persuasive medical analysis. They cite the Cass report from the UK. The overwhelming majority of medical authorities have rejected that and support healthcare for trans youth. Certainly puberty blockers at a minimum and cross-sex hormones. Again, we're not even talking about any surgical intervention. And the only real precedent that even falls anywhere along the spectrum here is abortion bans. I think they're very, very similar conceptually. You have another instance of a state prohibiting one particular kind of medical procedure and then narrowly describing when it is not permitted, and doing so in a way that seems, frankly, very much rooted in sex stereotypes and a subjective religious view of morality. But that's exactly what gives me a red flag about this case for the Supreme Court, because the Supreme Court didn't see a problem with that for abortion bans. So I'm not sure it'll see a problem when it comes to healthcare for trans youth.
How many statutes are you aware of across the country that prohibit minors from getting plastic surgery?
I believe the answer is 0, and I am also certain that the number of minors who receive breast augmentation surgery in this country every year vastly outweighs the number of children receiving, say, top surgery for a transition.
I would say even augmentation and even reduction.
Yes.
There are not, just like I knew girls when I was in the junior high or high school, a couple of girls who had breast reduction because their breasts they felt they were uncomfortable how big they were.
Yes. So under these laws, if you go to the doctor and you say, I'm a girl and I want breast reduction surgery because my breasts are causing me discomfort, that is legal. But if you go in and you say, I want breast reduction surgery because I am transgender or gender nonconforming, that is illegal and in many cases a crime.
That makes it really explicit as to what's going on there. This is about policing some type of gender ideology essentially, and that is born out of religious fundamentalism. All right, what else should we be talking about? Is there any other cases at the moment that we should look for, or is it worth our while more to talk about what's happening in terms of I want to talk about what DeSantis has been doing in Florida, and then also what we can anticipate in terms of cases, because the Trump campaign and the Republicans have already launched almost 200 cases around the country on furthering some type of election denial. They've lost a tremendous amount of them, but it does feel like they're setting up a predicate for a response in the event that Trump loses.
So I think there's just one more we should flag, Glossup versus Oklahoma, which shows the extremism of the death penalty jurisprudence today, because this is a case where the Republican Attorney General of Oklahoma does not want to execute a man. The man is named Richard Glossup. He's been on death row for decades. He's had multiple last meals. There's really strong evidence that he's innocent. There's really strong evidence that he was denied a fair trial and that prosecutors withheld key evidence that could have helped him avoid the death penalty. So the Attorney General says we don't want to kill him. The Oklahoma courts, which are very conservative, have ordered the Attorney General to kill him. And the Supreme Court of the United States must now decide, essentially, can the Oklahoma courts get away with forcing a state to execute someone who the state doesn't want to execute, or will Glossup live to see another day? And again, it's just one of those cases where to describe it is, I think, to illustrate the perversion and incoherence of how the death penalty operates today.
I mean, it's very rare that a court will supersede a prosecutor's recommendation for punishment. And this seems to be, well, this is obviously the most extreme that you can get in terms of superseding a recommendation in terms of punishment.
Yes, and I don't know how it'll turn out. The justices were all over the place. It was like they didn't have their morning coffee or Adderall or whatever they need to get on the ball. It was not a pleasant oral argument.
All right, let's talk DeSantis before we get to what you're sort of sussing out about the Trump legal strategy.
So I think most of your listeners probably know, your viewers know, that Ron DeSantis is on a mission to defeat Amendment 4, a ballot initiative in Florida that would overturn the state's current 6-week abortion ban. It needs 60% vote to pass. It's going to be a real climb. DeSantis is using a lot of taxpayer money to run ads against Amendment 4, but he has also begun
That seems like illegal.
That seems really bad, but he has also appointed almost the entire Florida Supreme Court, and the Florida Supreme Court said there was no problem with it. So he's spending millions of dollars of Floridians' own tax money to fight this, and he has also started to use overt censorship tactics of the kind that you would frankly expect in an authoritarian country. So what happened here is that proponents of Amendment 4 have this ad called Caroline, where a real woman tells the real story of how she would have been denied life-saving cancer treatment under the 6-week ban, and encourages voters to support Amendment 4. Ron DeSantis's top advisors hatched a scheme to send out letters from the Florida Department of Health to television stations airing this ad, about 50 TV stations, telling them that they had to immediately stop airing the ad or else they would be prosecuted and subject to potentially 60 days in jail for carrying political speech in support of the Amendment 4 campaign. A federal judge has issued a temporary restraining order that prohibits further threats. But just yesterday, DeSantis's Attorney General, Ashley Moody, filed a brief saying that the state stands by its threats, that the state feels it has every right right to criminalize speech in support of Amendment 4, and that the state plans to bring prosecutions if TV stations air this ad and they feel that the ad is causing some kind of damage within the state.
I mean, what based upon what?
So their theory is that this ad is false, which is not true. The ad is correct. There are real instances of women being denied cancer treatments because of the 6-week ban, because pregnant women need to terminate before they can get chemotherapy. The law doesn't let them terminate. So just to be clear, the ad is true. But they are saying that the ad is false. And they are claiming that the ad will convince women that they are not able to get medically necessary abortions in the state of Florida, and that they will delay care because of this misinformation from the ad. And that is a public nuisance, which constitutes a misdemeanor under Florida law that subjects violators to 60 days of jail time. I mean, a few problems there. First, this is a law that was designed to address like leaking septic tanks. Like literally that is what the law talks about, not political speech. Even if the law were directed at political speech, the Supreme Court has said over and over and over and over again that the government does not get to decide what is true and false in the realm of politics, that the government does not get to either directly censor or coerce censorship of political speech in support of a particular candidate or campaign. And the state of Florida has just rejected these precedents. I mean, they are using Floridians' taxpayer dollars to pay lawyers millions of dollars to reject these precedents and to argue that the state gets to be a ministry of truth and imprison people who spread a message about abortion that the state doesn't like.
Well, I am impressed that there's any ink left for you to write about this, because I'm sure there are folks like Glenn Greenwald and Matt Taibbi and a lot of COVID deniers who are using so much ink in writing about this incredibly obvious overreach by a government on the media and on the free speech, that there's any ink left for anyone else to even opine about this.
I keep waiting for some of these National Review guys who love Ron DeSantis and, claim to be First Amendment defenders like, Baseball Crank and Charlie Cook to come out swinging here. This is their opportunity to prove that they actually have some real principle, to say, I loved Ron DeSantis, but now he is engaging in the most egregious censorship campaign that we've seen in modern times. And yet all we hear are crickets, Sam. I don't understand why. Maybe you can wager a guess as to why. But these deep defenders of truth in the First Amendment have all suddenly gone silent in the face of this scandal.
It's fascinating. I'm sure they're just waiting. I'm sure they're waiting to drop like maybe it's an extended piece. Sometimes the lead time on these, my understanding is that it takes a long time for these longer pieces to get published. All right. Trump's legal strategy in terms of the election. It seems like it's both a legal strategy and a political strategy simultaneously.
They're flooding the zone with preemptive lawsuits, as you said earlier. These are not all even lawsuits that deal with any active issue. They are trying to set the stage through this litigation to question the results, to destabilize the count of ballots, and to potentially try to nullify ballots after the election to overturn the result outright. There have been some losses already. So, for instance, the Trump campaign has been trying to nullify ballots sent from military members who are stationed overseas. That has failed. The Trump campaign is currently trying to nullify ballots that are mailed by election day but arrive shortly after in states that allow that. So far, it hasn't worked. But there are some cases that do give me agita because they seem to tee up like a perfect Bush v. Gore situation for the Supreme Court if it comes down to it. So I'll give you like one example. In Pennsylvania, people are supposed to write the date on their mail ballots, but it turns out it's really easy to overlook the date line, so a lot of people don't do it. What happens if they mail back their ballots well before the election, or at least by election day, and everything else is good, but they forgot to date their ballots? Well, Republicans in the legislature argue that those ballots should be thrown out. A lower court has argued that those ballots have to be counted. And the state Supreme Court has basically said, we aren't going to get involved with this until it becomes a live issue after the election, which seems like a dubious strategy from the state Supreme Court, but I guess they're just doing watchful waiting. Either way, if this election comes down to like 500, 600 mail ballots in Pennsylvania, this is the litigation that the Trump campaign is going to use to try to swing the election. And I think that's why they're casting this wide net, because there are similar issues like this in every state really, but especially swing states with divided governments. And I think the goal is just to be in place, ready to spring out with a lawsuit if the election takes another sort of Bush v. Gore turn.
People have always wondered why it is that Pennsylvania in particular, why they do not allow the counting of mail-in ballots, early ballots, absentee ballots prior to Election Day. In Pennsylvania, if I remember correctly, they cannot start counting those ballots until Election Day, which ends up like, drawing the whole day out. It also sort of, it gives the opportunity for the Republican candidate to say, what's going on here? What kind of shifty things are they up to that it's taking this long to count the ballots? Well, it's because your own Republican Party wouldn't let you count them before Election Day, A. And B, it also means that these are live issues in the wake of the election. They cannot be resolved prior to then.
Yes. So just to be super clear about this, Democrats have proposed bills in Pennsylvania to allow for the early counting of ballots, modeled after states like Florida, which is a national model in counting and producing ballot results, on Election Day, pretty much as soon as the polls close. Pennsylvania Republicans have persistently denied and fought and defeated those measures to allow the early counting of ballots, specifically because this is a top priority of Trump and MAGA world. Trump and MAGA world understand that they have the most leverage after an election when the ballots are coming in, dribbling in, and slowly being counted, sometimes recounted by hand for days or even weeks after a race. They want to keep it that way. And so Trump has essentially gotten his allies in the Pennsylvania Senate, which is the one chamber controlled by Republicans, to prevent the enactment of a new law that would permit early counting of ballots. So if this comes down to Pennsylvania and on election night we don't have a result, it will be because Republicans have blocked laws that would do the sensible thing of just allowing these ballots to be counted when they're received rather than waiting until election day for no good reason.
And those of us who remember the 2000 election, remember how important calling Florida for Bush was important. It happened to be called by his cousin, this guy Ellis, who worked at Fox News, and how the Supreme Court said we have to stop the counting of the ballots in Florida because it may be prejudicial towards George W. Bush because he sort of is the default winner of Florida, even though we haven't established that yet. These presumptions end up what we perceive as just like, oh, that's just people's perceptions. They end up being operable or operative in these court cases. And that was a court that looks relative to the court today, looks like, a bunch of do-gooders essentially. And so that's, really important. What about Georgia? What's going on in Georgia? Do you have a sense?
I think Georgia is good news. So the Georgia Supreme Court has ensured that these crazy election board members who are trying to mandate the hand counting of ballots, along with several other sort of Trump wish list items that would have slowed down the count, that will all stay on hold. That is frozen. That will not happen in 2024. Instead, Georgia will play by the usual rules of allowing a relatively quick count without any prejudicial delays, genuinely prejudicial delays. So I think Florida's Georgia is a bright spot. I don't know that we'll get a clear result on election night, given how close it will be. But the Georgia Supreme Court, which I would say is dominated by like conservatives who aren't crazy, has done the right thing in preventing Trump and his allies from slowing down the count in a way that would give them leverage to try to overturn the results.
Well, we're doing a live show in person in front of almost 400 people in Brooklyn on election night. So we need to get this wrapped up by midnight.
Yeah, I agree that should be the number one priority of election officials and the campaigns. And I will definitely relay that information to them as best I can.
Is there someone I can sue? Because this is going to be a bit of a mess if we have to leave there after 5 hours and this ain't resolved.
If you do, I am not your lawyer. I just want to make that clear.
Fair. But people got to get paid. And if you know, Mark Joseph Stern, senior writer at Slate, thanks so much for your time today. We'll link to some of your more recent pieces, particularly this one about DeSantis. I think people really should read up on it. It's extraordinary what's going on down there. And we will, I guess we will next speak to you after the election, and we'll have a better sense of so painful to contemplate what's happening though the next 2 weeks, or frankly 2 months for that matter. We'll see, but really appreciate your time.
Always fun to come on, even when you end by destroying my mental equilibrium.
I'm sorry about that. Good luck trying to regain it.
Thank you.
Hey, folks, don't forget to hit the subscribe button and check out our daily show. We do it every day at 12 p.m. Eastern for about 2.5 hours. We even take phone calls. You should check that out.